I'm Gary Venner, CEO of IFA Acquisitions, and I'm joined by Alex Canham, who's partner of Herrington Carmichael, where we continue our second informative question and answer series under our YouTube channel to provide top tips and market update when selling an IFA business and an insight into the legal processes when buying or selling an IFA business by two industry experts. The title of this mini video is coming up on screen now. So Alex, TUPE. I think everybody's got to bear that in mind if there are staff involved in the sale of a business and those staff are going to continue with the acquirer. And just like to hear your views on when it affects a business, because a share purchase, normally you would expect that to happen, but not necessarily, I suppose. TUPE is not really required if the company is going to continue, just change of owners, and the company is going to stay the same. However, if it's going to be integrated into another business, we pretty much know that TUPE applies. But then what about asset sales and things like that? Can you give us an understanding of when TUPE needs to be considered?
You're right, Gary. The TUPE regulations are there primarily to protect employees' rights. They're more prevalent in the case of somebody acquiring a client book or the business and assets of a business rather than in a share transaction. And the primary purpose there is to ensure that buyers don't come in and make significant changes to the employees' terms and conditions, or indeed try and strip out employees from the business. It gives them continuity and sort of a general protection their employment will carry on and follow the business when it's moved from the selling entity into the buyer. TUPE in itself requires sort of a lot of attention early on in the process. Often people leave it right to the very end, and whilst there are certain steps that you can take during the process, having it in the forefront of your mind as a seller early in the process is really important. The primary reason for that is because you've got an obligation to consult with your staff.
Yeah, and just going back to that, I think a lot of people will be interested to hear, it does affect those that are just doing an asset sale, because I think a lot of people think that it won't. We're just buying the clients only. I'm not actually taking over all the staff. But what you're saying is you still need to concern yourself with TUPE.
Very much so. Yeah. From the perspective of TUPE, buying a selection of the clients and a material part of that business is the same as if you're buying the whole business, the brand and everything, lock, stock and barrel, and moving it out. Yeah.
And talking to staff, important. And there's the existing employer needs to have a conversation, and also presumably the new employer. Am I right that both need to be involved in that process?
Yes, that's right. So there's the legal requirements, and then there's the sort of practical side of things. And I suppose taking each in turn, the legal requirement is that the seller has an obligation to inform and consult with their employees.
Yeah.
And what that means in really broad terms is to sit down with them and talk to them about what the transaction means, what's happening, what their any impacts will be for them in terms of their role, and ultimately disclose certain terms relating to the transaction and how it means to them.
Yeah.
From the buyer's perspective, it's more about the practical side than the legal, because the buyer's obligation is to disclose to the employees if there's going to be any what we call measures. And that's going to be certain permitted changes to their terms of employment, such as changing the place of work, changing the name of their employer.
Right.
The real benefit for acquirers, though, I think, in being engaged in that process is ultimately making sure the staff feel engaged and part of that process, because then you risk not having staff who are as engaged in the process and potentially then don't want to stay along and support that transaction that's key for both parties.
Sure. And am I right that if an employee, their job is protected, they're going to have the same type of role, the same pay and the benefits, etc., then even though they're going to be consulted, they can't really object to the sale going ahead, because their role is still open and they are not going to be disadvantaged. Am I right in that?
In broad terms, yes. So the employees, once they've been given all the information and consulted with, and they understand what that means for them and their role, they ultimately will automatically transfer to the buyer when that business and asset sale completes, and their employment will move across by operation of law. They do, however, have the right to object. They can't stop the whole sale going through and the transaction between the buyer and the seller, But as an employee, they can object and say, I don't want to participate in that, and I would like to bring my employment to an end when the transfer occurs. So we do see occasionally certain members of staff who say, actually, I don't want to go across, even though my terms are safeguarded, and they've got that right to object as a matter of law.
But that doesn't automatically mean that they will be getting a redundancy, is that right?
That's right.
Because they were offered a role.
Correct. That's absolutely right. Really, the point that they object and that objections comes into a force on completion, their employment's deemed to be terminated at that point, and it's treated effectively like a resignation.
And what happens, Alex, if certain roles are not required? So, for instance, a directly authorised business is being sold, and there are certain aspects of making sure doing all the data reports, etc., maybe some compliance issues, that's being covered by that individual, but they're not needed by the acquirer. Presumably redundancy is the way forward on somebody like that.
That's right. There would have to be a process that would take place after the sale is concluded. You wouldn't be able to do it prior to the acquisition, and the buyer doesn't have the luxury of being able to say, I'll keep all of my people but none of the people from the acquired business.
Right, yeah.
They would have to run a process following completion that's done very diligently, because of the protections that are given to the transferring staff under TUPE. So they would have to go through a sort of an objective process afterwards and really follow quite a robust process in terms of how they document that to ensure that there weren't any potential liabilities under TUPE in the event that they make an acquired employee redundant.
Yeah, absolutely. Now, my understanding is there isn't really a set period of time before when this consultation needs to happen, and indeed it's always that question of when do I tell my staff, because what happens if this deal doesn't go through, and even at heads of terms may have been signed, but they're non-binding. Often it's until exchange really happens that there is a commitment, and sometimes, as we see, sometimes exchange and completion can be simultaneous as well. So but I think, if I'm right, that do nothing and do not consult your staff, then that could land the the process in costs and awards, because you must consult before the deal goes ahead.
Absolutely. A failure to inform and consult entitles each employee to an award of 13 weeks' pay. So it's quite a significant liability, and often when we raise that with clients, that's a pretty good incentive, if nothing else, to actually engage with the workforce in a timely manner. There isn't a formal statutory timeline for saying when you must inform and consult. The language is when you realise that a transaction is in effect reasonably likely to happen. So you mentioned heads of terms, and often that is the first trigger point where a deal is in serious contemplation and you've entered into exclusivity. But even then, there's still a lot of negotiation and a lot of things that could happen that mean the transaction's unlikely to occur or doesn't take place for some reason. So we find that a lot of clients tend to take an informed risk approach, and despite knowing that they need to do this, they often will do it later in the process once they're certain that either the main purchase terms are nearly finalised, or that they're potentially exchanged contracts and they're in that window between exchanging when the contracts are binding and completion when the sale actually occurs.
I think that's what we tend to see as well here. Heads of terms get through the due diligence or the bulk of the due diligence, knowing that this deal is all going ahead, and getting the right timing is the right thing. I think from what you said though, there is a potential do it wrong, and there could be some penalties. It does mean make sure that you consult with your lawyer to make sure that TUPE is high on that agenda. Are you ticking the box? Have you done everything you should be doing as well now?
Definitely. I think it should be one of the conversations you'd be having at that outset stage, is in terms of practically how you're going to manage the messaging to the staff and what that vision is about why you're doing the transaction and what it means for them, because ultimately that means generally less risk of attrition and
absolutely
staff disruption. But from a legal perspective, also then forces that conversation about how you're going to communicate the transaction to them. And in legal terms, there's sort of a magic number of about 9, where ultimately if you've got more than 9 employees, the process under TUPE is a lot more robust and detailed than it is if you have fewer than 9 employees. So understanding exactly which process and route you have to follow early will make sure that you stay the right side of the regulations.
Yeah, absolutely. Thank you. Subscribe to our YouTube channel and switch on notifications so that you won't miss our next video in the series of top tips and market update when buying or selling an IFA business, and an insight to the legal processes by two industry experts, me, Gary Venner, CEO of one of the UK's largest specialist brokers in IFA Acquisitions, and Alex Canham, partner from Herrington Carmichael, who are leading commercial lawyers specialising in IFA mergers and acquisitions.